these are human beings, and it doesn't surprise me neither, because if you look in any industry that's going on, like that type of abuse of power or so on and so forth. You know what I'm saying? So, but
Okay.
I think it's gonna take other lawyers to call them out, because as a civilian, I don't know what all of their ethical clauses are. You know what I'm saying? But another lawyer does.
Right. And anybody can go to, I tell people I go to the Florida Rules of Professional Conduct, and I read them as I've had to read the judicial canons. This is where I think it's going to be a little bit interesting, particularly as we move forward with a couple of cases that I actually have. And I'm actually suing a law firm, among other people, that I argue filed a sham pleading. And I believe, candidly, I think that the cases that we have in the appellate court, or that I have in the appellate court, is based on sham pleading and lawyer misconduct, because the lawyers misrepresented uh, facts to not only the trial court, but to the district courts of appeal. So, and there's a thing that's called intentional misrepresentation of a material fact, and or the deliberate omission of a material fact, which could form the basis for arguing fraud on the court. Chris.
Yo, I did have something to say about that frivolous lawsuit thing. Oh, the frivolous litigant thing. Now, I had
Whoa,
a
whoa, whoa,
judge,
whoa, whoa, whoa. Vexatious litigant?
vexatious litigant, sorry.
Okay.
Um, um, they they filed one of the judges in my case for the child support case, the original child support case. She mentioned that, and her findings of the final order that she mentioned before I took it to appeals. She said that, but when I did my research on it, they actually supposed to have a hearing on that. They can't just read something and say, "Well, this is what he put in the filing." Like, they have to have a hearing on it to basically understand what you're, well, in Georgia anyway. They're supposed to basically understand what you're talking about, and what accusations that you're making.
Okay, hold on. So let's roll back. And again, for anybody listening, it's not legal advice. They if they notice you and you don't respond, you don't forget, if you don't raise it, you may waive it. But yes, you're entitled to a hearing on the facts, or some may call it an evidentiary hearing. But a lot of times, and then unfortunately, what we've learned through self-representation is that a lot of people just don't respond. And I think Mike was saying that, and I know Daly was as well. You just got to respond. Otherwise, you actually may have waived it. Now, you may be able to go back and get it again, or go back and try to reclaim it and potentially argue there's some fundamental violation by not allowing you to proceed. But without me actually looking at it, I probably couldn't be of help. But I'll just say this: if you're ever accused of being a vexatious litigant, like they try to impose sanctions against me, and then I fought back, and now everybody's saying, well, now second DCA, you can't really address the issue because it's a non-final order. And I'm like, well, bitch, then why the fuck did you file it? Okay.
Yeah.